Good day, ma'am. My name is Analou Cardinas from BSSM 3A. I'm going to report Laws Regulating Transportation Establishments, Chapter 7. From the time the wheel was invented, man began to travel and explore different corners of the world. In modern times, with the invention of this first flying machine and marine vessel, tourism started to grow at fast pace. Transportation as a business careers with it not only high returns but great responsibility for many lives are at stake in this risky sector of tourism. Learning objectives: identify the laws affecting the transportation sector, identify the rights of passengers of commercial transportation, explain the relevance of these laws to the promotion of tourism in the country. Topic outline: Law on common carriers, responsibility of common carriers, liabilities of common carriers for the act of employees and strangers, enforcement of liability of common carriers, registration of aircraft, seatbelt law, law on transportation of animals, law on import of vehicles, public service laws, traffic laws, and conclusion. The Philippines has become one of the promising tourist destinations due to the extraordinary hospitality of the Filipinos and the diversity of tourist attraction in the country. However, one challenging aspect of promoting inbound tourism in the Philippines is the security and safety issue. On one hand, some of the best transportation and travel professionals are Filipinos, seafarers, pilots, drivers, flight attendants, cabin crew, aircraft mechanics, and etc. On the other hand, some of the worst recorded transportation disasters and accidents are in the Philippines. The transportation sector is therefore greatly affected by this concern. This chapter will deal with the different laws affecting the transportation sector as they are integral in the study of tourism. Law on common carriers. The primary law that governs common carriers is the Civil Code of the Philippines as clearly implied from Article 1766 thereof, which states that in all matters not regulated by this code, the rights and obligations of common carriers shall be governed by the Code of Commerce and special laws. The law. Article 1732. Common carriers are persons, corporations, firms, or associations engaged in the business of carrying or transporting passengers or goods or both by land, waters, or air for compensations, offering their services to the public. Discussion of the law. A common carrier is defined as one holding itself out to the public as engaged in the transportation of freight or passengers for hire. It is one who is in a business or transporting goods or persons for hire as a public utility. A private carrier, in contrast, it is not a business of transporting public employment but hires out to deliver goods, not passengers, in particular cases. Both Civil Code and Code of Commerce give a clear-cut division between contract of carriage of cargo and contract of carriage of passengers because the rights and defenses in each kind of contracts are different from the other. Responsibility of common carriers. Article 1733. Common carriers from the nature of their business and for reason of public policy are bound to observe extraordinary diligence in the vigilance over the goods and for the safety of the passengers transported by them, according to all the circumstances of each case. Article 1755. A common carrier is bound to carry the passengers safely as far as human care and parents can provide, using the utmost diligence in case of death or injuries to passengers. Common carriers are presumed to have been at fault or to have acted negligently, unless they prove that they observe extraordinary diligence as prescribed in Article 1733 and 1755. Discussion of the law. As soon as the passengers put his foot on the platform, the obligation of extraordinary diligence of common carriers begins. The relation of carriers and passengers does not cease at the moment the passengers alight from the carrier's vehicles at place selected by the carrier at the point of destination, but continues until the passengers has had a reasonable time or a reasonable opportunity to leave the carrier's premises. A certificate of public convenience is not a requirement in order incur liability. Such liability arises from the moment a person or firms act as a common carriers, whether or not such carriers has been granted a certificate of public convenience or has complied with the requirements of the applicable implementing regulations. The term extraordinary diligence has been defined as a standard of care required of common carriers bringing safety its passengers. It is the obligation of the common carriers to bring passengers safely. The next is liabilities of common carriers for act of employees and strangers. The law. Article 1759. Common carriers are liable for the death or injuries to passengers through the negligence or willful act of the former employees, although such employees have may acted beyond the scope of their authority or in violation of the orders of common carriers. The liabilities of common carriers does not exist upon proof but that they exercise the diligence of good father of a family in the selection and supervision of their employees. Discussion of the law. For a bus company, due diligence in selection of employees is not satisfied by finding that the applicants possess a professional driver's license. The employer should also examine the applicants for his qualification, experience, the record of service. Due diligence in supervision, on the other hand, requires the formulation of rules and regulations for the guidance of employees and issuances of proper instructions as well as the actual implementation and monitoring consistent compliance with the rules. For a shipping company, the vessel must be considered seaworthy, adequately equipped for the voyage, and manned with sufficient number of competent officers and crew. Enforcement of liability of common carriers. Liability of common carriers can be enforced of the following causes of action. Number 1. In case of death or injury caused to passenger, the victim may file a case of breach of contract of carriage or culpa contractual against the owner of the common carriers. Number 2. In case of death or injury caused by a stranger or pedestrian, the victim may file a criminal complaint against the driver of the common carriers for reckless imprudence resulting in homicide and damage to property. The victim may also file a civil suit against the common carriers and its drivers on the ground and of culpa aquiliana or quasi-delec. The law. Nature of airline, bus, shipping tickets. The best evidence of a contract of carriage is the passage ticket. Under our jurisprudence, an airline, bus, or shipping ticket is a contract of adhesion considering that all the provisions thereof are prepared and crafted only by the carrier. The only participation left of the other party is to affix his signature thereto. In this situation, the Supreme Court ruled that the terms thereof must be interpreted against the party who drafted the same, in this case, the carrier. Discussion of the law. Such contracts of adhesion are not entirely prohibited and are in fact binding regardless of whether or not the passenger or shipper had read the provisions thereof. Thus, it was held that even if the passenger had not signed the plane ticket, he is nevertheless bound by the provision thereof. Such provisions have been held to be a part of the contract carriage, valid and binding upon the passenger regardless of the latter's lack of knowledge or assent to the regulation. The one who had adheres to contract is in reality free to reject it entirely if he adheres. He gives his consent. Even the conditions are printed in small letters does not make it the ticket or bill invalid. However, the courts will exercise greater vigilance when dealing with the contract of adhesion in that the said contract must be carefully scrutinized in order to protect the weaker party from deceptive schemes contained in ready-made stipulation. This is in recognition of Article 24 of Civil Code, which mandates that in all contractual, property or other relations, when one of the parties is at a disadvantage or account of his moral dependence, ignorance, indigence, mental weakness, tender age or other handicap, and courts must be vigilant of this protection. Regulation of transportation business. The Department of Transportation and Communications (DOTC) is the primary policy, planning, programming, regulating administrative entity of executive branch of government in the promotion, development, and regulation of dependable and coordinated networks of transportation and communication system, as well as the fast, safe, efficient, and reliable postal transportation and communication services. It has the power, authority, and technical expertise to determine whether or not a specific transportation or communication project is necessary, viable, and beneficial to the people. Next is regulation of air transportation business. Legislative Act No. 3909, passed by the Philippine Legislature on November 20, 1931, created an office under the Department of Commerce and Communication to handle aviation matters, particularly the enforcement of rules and regulations governing commercial aviation as well as private flying. It was amended by the Act 3996 to include licensing of airmen and aircraft, inspection of aircraft concerning air traffic rules, schedules, and routes, and enforcement of aviation laws. Next is standard requirements for tourist land transport vehicles. To be registrable, every tourist transport must be found roadworthy upon inspection by a team from the Department of Tourism. In case of bus or coaster, it shall not be more than 10 years, were reckoned from the year of manufacture. For a tourist car, it shall not be more than 5 years, reckoned from the year of manufacture, provided, however, that tourist luxury cars shall have maximum allowable age of 10 years. For this purpose, luxury cars shall refer to passenger cars with engine displacement or not less than, and which are not locally assembled, manufactured. Every tourist transport shall be provided with a left-hand drive. It shall be properly equipped with adequate air conditioning units, and it shall be provided for installed with at least one portable fire extinguisher for the protect of its passengers. For tourist buses or coasters, a public address system shall be installed. Every tourist transport unit shall be provided with a first aid kit and an adequate supply emergency medicines. It shall have clean and comfortable seats and shall have enough legroom and sufficient storage space. Lastly, every tourist transport operator shall provide adequate garage and repair shop for the maintenance of equipment, as well as a parking space sufficient to accommodate all registered units. Next is standard requirements for tourist air transport. Adequate life-saving devices and adequate communication equipment should be provided in accordance with the requirements prescribed by the Air Transportation Office. Next is documents required to support application for accreditation to operate as tourist transport operator. A. Mayor's permit and/or municipal license. B. Business name certificate and all amendments thereto, if any, in the case of single proprietorship. In case of corporation or partnership, a certified true copy of the article of corporation, bylaws or articles of partnership and amendments thereto, if any, duly registered with the Securities and Exchange Commission. Letter C. Proof of ownership or contract of lease over an area adequate to serve a maintenance depot and garage of all its units not applicable to water transport. Letter D. A list names of all officials and employees under respective designation, nationalities, home address, certified correct under oath by the General Manager, President, and such other papers or documents as may be required from time to time by the Department. For land transport, a copy of LTFRB, Certificate of Franchise or Authorization for Tourist Car Bus Service, a copy of transportation routes as approved by the LTFRB, pictures of vehicles showing the side, back, and front views thereof with the company's name and logo imprinted at its near and sides respectively. Such other papers or documents as may be required from time to time by the Department. For water transport, a copy of Certificate of Public Convenience and Necessity issued by Maritime Industry Authority, a copy of transportation routes as approved by the Maritime Industry Authority, like pictures of the vessel showing the side, back, and front view thereof with the company's name and or logo imprinted at its sides. Next is the copy routes to be served and scheduled. Last, such other papers or documents as may be required from time to time by the department. For air transport, a copy of Certificate of Public Convenience and Necessity issued by the Civil Aeronautics Board. A copy of transportation routes is as approved by the Civil Aeronautics Board. Pictures of the plane showing the side, back, and front views thereof with the company's name and or logo imprinted at its sides. List of operation and maintenance officials and personnel with their ATO licenses. Copy of the routes to be served and flight schedules and such other papers or documentation as may be required from time to time by the department. The next is Seatbelt Law. The Seatbelt Law was enacted to secure and safeguard its citizenry, particularly the passengers and drivers of private and public motor vehicles, from the ruinous and extremely injurious effect of vehicular accidents. In order to secure the safety of the passengers and driver at all times, the mandatory enforcement of the use of seatbelt devices by the drivers and front seat passengers of private and public motor vehicles shall be enforced. Discussion of the law. The highlights of law are as follows. The drivers and front seat passengers of public vehicles are required to wear or use their seatbelt devices while inside the vehicles of running engine or any road of throughout fare. In addition, the driver of a public motor vehicle shall be required to immediately inform and require the front seat passenger upon boarding vehicles or running engine to wear the prescribed seat belts. Any passenger who refuses to wear seat belts shall not be allowed to continue his or her trip. Number 2, infants and or children ages 6 years old and below shall be prohibited to sit in the front of seat of any running motor vehicles. It shall be unlawful for a person to import or cause the importation of any vehicles without appropriate and operational seatbelt devices. Number 4, for new vehicles, compliance is required for registration. Failure to comply shall disallow the registration and or renewal of the registration of vehicles at the LTO. Law on Transportation of Animals. The law, by virtue of Republic Act 8485, also known as Animal Welfare Act of 1998, it shall be duty of any operator of any land, air, or water public utility transporting pets, wildlife, and all other animals to provide in all cases adequate, clean, and sanitary facilities for the safe conveyance and delivery thereof their consignee at the place of confinement. These animals shall be provided sufficient food and water while in the transit for more than 12 hours, or whenever necessary. No public utility shall transport any such animals without a written permit from the Director of the Bureau of Animals Industry or his or her authorized representative. Any form of cruelty shall be penalized even if the transport has obtained a permit from the Bureau of Animal Industry. Cruelty in transportation includes overcrowding, placing animals in trunks or under the food trunks of the vehicles. Discussion of the law. In order to assure safety of passengers and crew members of aircrafts or vessels, it is necessary to obtain a shipping permit from the Bureau of Quarantine before an animals may allowed to transported on board. The Bureau of Quarantine has required the following documents as certified by a licensed veterinary doctor or veterinary clinic hospital to be presented before a shipping permit will be issued. Number 1, certificate of rabies vaccination for not less than 30 days. In case of international carriage, or certificate of 5-in-1 vaccination, parvo, influenza, lepto, deworming, distemper, and hepatitis may also be required. Number 2, for agricultural animals, certificate of clearance from the Cogen test on FMD, food and mouth disease test is required. On the other hand, a person planning to bring any animals into the Philippines from abroad must apply in writing of an import permit at the following address: All animals imported into the Philippines shall be subject to such quarantine and test as may be prescribed by the doctor of animals industry, and those found to be infected with the dangerous communicable animal disease shall immediately be condemned, killed, and properly burned or buried in the presence of representative of the Bureau of Animals Industry at the expense of the importer. The next is law on importation of vehicles. The law. There are relevant laws on importation of vehicles which may be useful for the transportation business, namely Republic Act 7227 allows a free flow of goods and capital within the Subic Bay Free Port in Subic Province of Zambales in order to attract investors to invest their capital in a businesses climate with the less government intervention. President Arroyo's Executive Orders 156 prohibits the importation of used motor vehicles into the country except A. On territories that are declared free port zones such as Subic Bay Free Port in Subic Province, Zambales by virtue of Republic Act No. 7227. B. If the vehicle is owned by a returning resident or immigrant and covered by an authority to import issued under the No Dollar Importation Program. If the vehicle is for use of an official of the diplomatic corps and authorized to be imported by the Department of Foreign Affairs, DFA, and if the vehicles falls under the category of special purpose vehicles such as ambulances, fire trucks, reefers, tankers, truck, and crane lorries. The next is public service laws. The law. Public service includes every person who may own, operate, manage, or control in the Philippines for hire or compensation with general or limited clientele, whether permanent, occasional, or accidental, and done for general business purposes, any common carriers, railroad or street railways, traction railways, subway motor vehicles, steamboat or steamship, line, ferries, and watercraft shipyard. Unless otherwise exempt, no public service shall operate without having been issued a certificate of public convenience or a certificate of public convenience and necessity. Discussion of the law. Public utilities are privately owned and operated businesses whose service is essential to the general public. They are enterprises which specially cater to the needs of the public and enterprises which specially cater to the needs of the public and conduce to their comfort and convenience. As such, public utilities services are impressed with public interest and concern. The same is true with respect to the business of common carrier, which holds such peculiar relation to the public interest that there is superinduced upon it the right of public regulation when private properties are affected with the public interest. Traffic laws. Republic Act No. 4136, which is enacted in June 20, 1964, is compilation of laws relative to traffic rules and regulations. Some of the highlights of the law are as follows. Rules on registration of motor vehicles. Number 1. No motor vehicle shall be used or operated on or upon any public highway of the Philippines unless the same is properly registered at LTO. Number 2. Tourists bring their own motor vehicles to the Philippines may, without registering such motor vehicles, use the same during but not after 90 days of their sojourn, provided that the motor vehicle displays the number plates for the current year of some other countries or state, and said number plate, as well as the same on the address, permanent and temporary, of the owner thereof are registered in the Land Transportation Commission prior to the operation of the motor vehicle. Number 3. For public utility automobiles, application for registration shall be accompanied by a certificate of public convenience, and motor vehicle registered shall be subject to the public service law rules and regulations. Number 4. No person shall operate any motor vehicles without first procuring a license to drive a motor vehicle for the current year, nor while such license is delinquent, invalid, suspended, or revoked, The license shall be carried by the driver at all times when operating a motor vehicle and shall be shown and or surrendered for cause of upon demand of any person with authority under the Act to confiscate the same. An examination or demonstration to show any applicant's ability to operate motor vehicles may also be required. Number 5. No person operating any vehicle shall allow more passengers or more freight or cargo in his vehicle than its registered carrying capacity. No driver shall permit any person to ride on the running board, step board, or mudguard of his motor vehicles for any purpose. Number 6. Every vehicle must be provided with sufficient car accessories such as tires, brakes, horns, headlights, taillights, stoplights, windshield, wipers, mufflers, and lights when disabled for the security and safety for the motor vehicle. Under letter of instructions dated December 2, 1974, every motor vehicle must have at all times at least one pair of early warning device consisting of a triangular, collapsible, reflectorized plates in red or yellow colors at least 15 centimeters at least base and 40 centimeters at the sides. So there is restrictions as to speed. Now, there is a restriction sa pagpakusog dagan. Number 1. Any person driving a motor vehicle on a highway shall drive the same at a careful and prudent speed, not greater nor less than is reasonable and proper, having due regard for the traffic, the width of the highway, and any other condition than under existing, and no person shall drive any motor vehicles upon a highway at such a speed as to endanger the life, limb, and promptly if any person, nor a speed greater than will permit him to bring the vehicle to a stop within the assured clear distance ahead. Parking prohibition. No driver shall park a vehicle or permit it to stand, whether attended or unattended, upon a highway in any of the following places. Letter A. Within an intersection. B. On a crosswalk. C. Within 6 meters of the intersection of curb lines. Letter D. Within 4 meters of the driveway entrance to and fire station. A. Within 4 meters to fire hydrant. F. In front of a private driveway. Letter G. On the roadway side of any vehicle stop or park at a curb or edge of the highways. And letter H. Lastly, at any places where official signs have been erected prohibiting parking. Driving or parking on sidewalk. No person shall drive or park a motor vehicles upon or along any sidewalk, path, or alley not intended for vehicular traffic or parking. Driving and substance intake. No person shall drive a motor vehicles while under the influence of liquor or narcotic drug. Obstruction of traffic. No person shall drive his motor vehicle in such a manner as to obstruct or impede the passage of any vehicle, nor while discharging or taking on passengers or loading or unloading freight obstruct the free passage of other vehicles on the highway. Duty of driver during an accident. In the event that any accident should occur as a result of the operation of a motor vehicle upon a highway, the driver present shall show his driver's license, give his true name and address, and also the true name and address to the owner of the motor vehicles. No driver of a motor vehicle concerned in a vehicular accident shall leave the scene of the accident without aiding the victim, except under any of the following circumstances. Number 1, if he is the imminent danger of being seriously harmed by any person or persons by reason of the accident. 2, if he reports the accident to the nearest office of the laws, or Number 3, if he has to summon a physician or nurse to aid the victim. If we desire respect for the law, we must first make the law respectable. Luis de Bendis. Conclusion. Laws regulating transportation establishments focuses on the legal guidelines that governs the transportation industry. These regulations are designed to promote safety, fairness, and accountability by setting standards for vehicles maintenance, driver qualifications, insurance requirements, and passenger rights. The laws also address issues such as pricing, routes, and the prevention of monopolies in the sector. Overall, these laws are essential for ensuring a transportation service operate in a responsible and organized manner, benefiting both businesses and the public. That would be all for the chapter 7. Thank you.